Yes.
My Lords, I'm going to ask you to turn up the judgment below now. It's at Core Bundle tab 15. And can we pick it up from page 141, so the beginning? And just to remind you that at paragraphs 3 to 5, the court below, the tribunal, correctly accepted that the substantive provisions of the Competition Act have extraterritorial effect. And then if we move on to page 150 of the bundle, what the court says at paragraph 32, they say the central point which this judgment must resolve involves the true meaning of the words any person in section 26.1, where we agree that that is the central question. And then if we go to paragraph 41, please, on page 153. Again, the tribunal's correct here to say that the effect of section 59 of the Act is to rewrite the meaning of person for the purposes of part 1 to include an undertaking, so that's correct. And then at 42, this is the point, that the nuanced point that I averted to earlier. So the tribunal found that section 5 of the Interpretation Act continues to apply. We say that it doesn't apply because it doesn't include the meaning of person. But be that as it may, we do accept that if there were a strong indication or signal of contrary intention, then of course the court would look at that and take it into account. Yeah. And the tribunal there says we consider that a court would have to tread with remarkable care and be extremely confident as to the existence of a contrary intention. Again, we say that that's correct. Now, 43, paragraph 2, the tribunal there says there are examples from within part 1 of the Act where the term person is clearly being used in a narrower sense than the expanded definition. Section 27 provides for a power in the CMA to enter business premises without a warrant. And you see there that the tribunal takes the view that that's one such example. So an investigating officer entering any premises under this section may require any person to produce any document. Well, we disagree with that, and I've shown the court section 27, which plainly envisages that an undertaking can occupy premises, so we don't agree with what the court says here. Then if we skip on please to paragraph 59 on page 159.
I think you agree with the broader proposition that in some cases Parliament has used, it has a number of, sometimes use undertaking to cover natural legal person or broad undertaking. Sometimes it says natural person or legal person, for example, interviews. So it deliberately chooses what sort of being should be subject to or can exploit rights or obligations. That's
correct. And there may be some examples of cases where person is used, where it could only be an individual, where that's absolutely clear as a pikestaff from the context. And then we say fine, but this isn't one of these situations because any person in section 26, there is no contrary indication, and it does apply, we say, the section 59.
The first sentence is correct, the second sentence is not.
Sorry, my lord, so that's back to...
Yes, 43.2. Yes. There are examples.
Yes.
There are
examples. So the first sentence is correct. The second, the example that's selected is not correct.
Yeah.
Then if we go to paragraph 59, page 159, and the footnote. And so can I just ask the court, just so I'm not reading it out, to read paragraph 59 and the footnote again?
Yeah.
And really the point that we make here is that the court is, with respect, doing precisely what the Supreme Court said in KBR is impermissible, namely rewriting the statute by reference to this concept of a territorial connection. We see that in the footnote too, which is imprecise and which doesn't have any foundation in the statute itself. That's exactly what the Supreme Court says shouldn't happen. And then if we go on...
But it's wrong as well, isn't it? Because even if you look at territorial connection, on your case, there is at least an arguable territorial connection by virtue of sections 2 and 25.
Yes. So, yes, well, I think what the tribunal is saying here is that that they're using territorial connection as a touchstone in individual cases to determine what's in and out of the Act, and we say, well, that's rewriting the statute. But you're right, my lord, we do say that section 2 and 25 and indeed 18 make clear the territorial scope expressly. And then if we move on to paragraph 66 on page 162, this is where the court dismissed summarily the CMA's argument under what's now ground 1. It called it the more muscular argument, but it doesn't really give any real reasons. It just says it's obviously wrong. Well, with respect, we obviously disagree with that.
Sorry, paragraph
66.
66.
Yes. So that's saying, that's repeating, that's reflecting the CMA's argument that any person means any person, because there is no express territorial limitation. And they say, well, that's obviously wrong. Well, we disagree, and the judgment doesn't really explain why. It really focuses on ground 2, and it does that on the basis that if we're wrong on ground 2, which it found we were, we must also be wrong on ground 1. I'm calling them grounds 1 and 2, but you understand what I mean. Ground 2 meaning being the undertaking point. If we go on to paragraph 71, we have no doubt that the CMA's construction, this is of undertaking, so this is now moving on to our argument, which we've called ground 2 in these proceedings, which is undertaking means undertaking. We have no doubt that the CMA's construction renders section 26 aggressively extraterritorial, because an undertaking is economic in conception, and because economic entities will more often than not be international and straddle and cross territories and borders. That's inevitable. Now, we agree with the characterisation of an undertaking straddling borders, but we say that's a very strong and powerful point in our favour, because Parliament has expressly included the word undertaking, knowing that they straddle borders. So Parliament has expressly made clear that these provisions have extraterritorial scope. We don't agree with the characterisation of aggressively territorial, and let me explain why. Because it's not aggressively territorial, because the undertaking has brought itself within the United Kingdom. It has a presence in the United Kingdom. That's on our ground 2, which is what the tribunal's considering. Paragraph 72 provides a hypothetical example, and let me take that in stages. So the tribunal there explains why the CMA's construction under what's now ground 2 is aggressively territorial by an example. And they take, you can see this at subparagraph 1, an undertaking U comprising multiple legal persons in various jurisdictions. U1, 2 and 3 have UK territorial connections, not said what's meant by that precisely. 4 and 5 have no such connection apart from being in the same undertaking as 1 to 3. Their sole connection is in the case of U4 with the EU and in the case of U5 with Ruritania. So that's the hypothesis. And then over the page, the CMA serves a section 26 notice on U, on the undertaking. Clearly, in order to be effective, the notice will have to be brought to the attention of a natural or legal person, for an undertaking being an economic entity doesn't have the important attributes of legal persons like companies, which enable service and the like. Undertaking, so pausing there, if all the tribunal means by that sentence is proper notice has to be given, and that might well, as a matter of practicality, involve bringing it to the attention of one of the natural or legal persons in the undertaking, then we've got no problem with sentence 2. If they mean something more than that, which is that as a matter of law, the notice has to be given on a company or an individual, qua company or individual, then we say it's wrong. The third sentence, undertakings do not have registered offices or officers. This is an issue we'll be returning to, as it is to our mind very significant to the question of construction. But of course that's wrong, and we've seen that in the Act. So we've seen that undertakings can have officers and can have premises. For the present, we'll assume that notice is brought to the attention of and served on U1, an entity with a UK territorial connection. Although our understanding of the CMA's case is that service on one of the entities without a UK territorial connection would suffice. And then we see, if we go to 4, so far as the entities without a UK territorial connection are concerned, the effect of the notice is plainly extraterritorial and very likely to undermine comity between nations. A foreign jurisdiction is unlikely to be impressed by the imposition of an obligation on a legal entity operating solely in its jurisdiction to provide an administrative authority in another jurisdiction under threat of sanction with documents and information. Now, we disagree with that because it defeats the whole point of person, including undertaking, as a unitary whole. So it's wrong to think of the undertaking being extraterritorial or service on the undertaking having an extraterritorial component. If the undertaking is in the UK, which it is, then there isn't an extraterritorial component because the Act deems the undertaking to be one body.
Is it right, just as a matter of policy, that it offends comity? I mean, almost every antitrust regime around the world is extraterritorial.
My lord, that was going to be, that's exactly right. And we've seen
in the US, I remember the Supreme Court dealt with this 100 years ago almost, about extraterritorial effect of the Sherman Act.
My lord, precisely so. And what you do have before you are the provisions in relation to the European Commission and the ECN directive, showing that this is...
It doesn't apply within the EU, within the states of the EU, because they agree that there's got to be reciprocal enforcement and respect, cooperation.
Well, there are no... sorry, my lord.
There's not a problem within the EU because of the ECN.
No, well, within the EU itself. Yeah. But precisely, but when one's looking, just going back to your point, my lord, about does it really affect comity between nations? No, with respect, no, it doesn't. The judge was wrong to find that. The court was wrong to find that because, as you say, it's competition regimes very commonly operate in this way because otherwise they would be ineffective. And in relation to the precise point about serving information, compelling information and documents from undertakings, we see that the Commission does that. The Commission serves notice on an undertaking which bites in relation to documents and information held by the undertaking outside the EU. And so the irony in this case, where the Commission is investigating the same suspected infringement, is, as I said at the outset, that the Commission can impose and has imposed a request for information on the BMW undertaking, which would extend to documents held, for example, in the UK. But on the respondent's case, the CMA can't do the analogous thing. And we say that it can't possibly be contrary to the Comity of Nations when other sophisticated competition regimes are doing precisely the same. Then we go to subparagraph 5. A further problem relevant to the intra- and extraterritorial effect of the notice is that U1 may not actually know the true extent of undertaking U. An undertaking is, as we've repeatedly emphasised, an entity economic in conception, and the number of natural and legal persons falling within the undertaking may be uncertain. This is especially the case since a corporate group may comprise or be part of different undertakings, depending on the economic activities of each of its component persons. So this is like the inter orem argument run by the respondents. Oh, we throw up our hands, we just don't know what's in the undertaking. And we say that that's wrong because the concept of an undertaking is clear under the law and is the concept that applies to the substantive prohibition and to the penalty provisions. So if it's clear enough for that, then it's clear enough for this. Then we see at 74, if we go on to paragraph 74, over the page, and just pausing on 74.2, the practice of the European Commission. So the practice, we doubt if such practice would assist in informing the separately framed powers of the CMA under the 1998 Act. But again, with respect, we disagree because, as you've seen, the Act was modelled on EU law, and so it's wrong to say that that the scope of EU law is irrelevant to the scope of section 26. Then if we move on to paragraph 74(4), which I think is the paragraph that Lord Justice Green said that you were finding perhaps a bit puzzling, and we agree, because the tribunal here accepts that the substantive provisions of the Chapter 1 and Chapter 2 prohibitions have a degree of extraterritorial application. It then says, we consider this would suggest that the powers in the CMA to investigate infringements of these prohibitions to be similarly extraterritorial, yes. But then, however, the extent to which such considerations have a material bearing on the construction of Section 626 seems to us to be verging on the minimal for these reasons. And we say that's wrong. And let's look at the reasons. So, reason 1, investigation precedes any finding of infringement. An investigation may find no infringement at all. There's no necessary correlation between the powers needed to investigate an infringement and the infringement itself. Now, I can't assist the court with that point because I just simply don't understand what's being said there. If it's simply a temporal point, investigation precedes decision, well, of course it does, but you can't have substantive enforcement, effective enforcement of the provisions without an effective investigation.
I think the correlation that does exist is the reasonable grounds for suspecting in section 25(2).
Yeah.
And there's no analysis in the judgment of 25(2). And that actually says, when you investigate, you've got to have in your mind, in your office, sufficient information to at least create reasonable grounds for suspecting an infringement of section 2 or 18.
Yes.
And if you don't have that, then there is no correlation. If you do, you have correlated to the potential infringement.
Yes, exactly. So I think that is the correlation, my lord. Yes, I agree.
And is this right? Following on from Manuel's point, actually there's no analysis of section 25 at all.
I think none at all.
Section 2 gets a reference in the paragraphs
outset.
at the outset, but not referred to again.
Yes.
And 25 isn't referred to.
I think that's right. I'll be told if I'm wrong, but I can't recall any analysis of section 25. So little Roman 2, it follows that extensive extraterritorial powers may be required to investigate a purely domestic infringement and vice versa. Well, that's a neutral point. That doesn't really shed any light on anything. And then 3, we quite appreciate that broad investigatory powers are, from the point of view of enforcement, desirable, but desirability doesn't easily translate into a factor to construe a power as having extraterritorial effect. Well, of course, we're not saying, it's not our case, that it's simply desirable. Of course, that doesn't get us very far. I wouldn't expect the court to say, well, we're right because it's desirable. We're right because it's what the statute says, and we're right because if on the respondent's case, an important aim of the Act, purpose of the Act, would be frustrated. Then paragraph 76 at the bottom of the page, the problem with an economic unit of account is that when legal processing is engaged, a process of translation needs to take place, whereby an economic concept is rendered into a legally comprehensible form. Such translation is vital for due process. As we've noted, none of the mechanics necessary for bringing a notice to the attention of a responsible person exist in the case of an undertaking. And the example we used in paragraph 72, it was necessary to identify which natural or legal person should be served with a section 26 notice. It makes no legal sense to serve an undertaking, but you'll have seen that that is wrong on the basis of the express provisions of the Act that I took you to. No process of translation is required. Parliament has made crystal clear in the Act what an undertaking can do. And as I've shown the court, the Act does indeed provide that an undertaking can be served with the Section 26 notice, as it can in other sections be served with other notices. I took you through all of the sections which contemplate that an undertaking can be given a notice in various contexts in the Act. So this is just incorrect as a matter of fact. And then we see at 77, this in our judgment fatally undermines the CMA's construction of section 26. So the fatal undermining doesn't have a proper foundation. And the tribunal then draws an analogy with civil proceedings under the Competition Act. And they say effectively, well, if you're bringing civil proceedings, those are against a company. But civil proceedings are not the creation of the Act. They're claims for breach of statutory duty. And if the tribunal is saying here that undertakings can't be the subject of civil or criminal proceedings, that's clearly wrong, because I've shown you sections 34, 37 and 58 of the Act, which in terms contemplate that they can be. And for the same reason, subparagraph 4 over the page is wrong. So this idea of a translation of the economic entity is inconsistent with what Parliament's done, which is to deem an undertaking a person for the purposes of Part 1 of the Act.
Looking at 77, 2 and 3,
Yes.
you can't bring a claim against an undertaking. Well, you bring the claim in accordance with the civil procedure rules against someone who is convenient, but the pleading is they and the rest of the company constitute an undertaking. The undertaking breached section 2, it caused loss, the quantum was X. Can we have a remedy, please? I'm not quite certain what that means, because the pleading itself will refer to the undertaking. You may find a convenient peg for the claim by finding a natural or legal person or persons, or you might, as we've seen in some cases, have 15, 20, 25 defendants, all of whom constitute the undertaking.
My Lord, exactly right. So as similar to the point we were debating previously, which is the giving the notice to the undertaking, a convenient legal peg might be one of the companies that makes up the undertaking. But as you say, my Lord, the claim is in respect of the undertaking. And I don't think the court needs to decide this point in this case, but it may well be, because of how Parliament's framed the Act, that it is possible in lots of cases to bring a claim against the undertaking qua undertaking. It's not what happens in practice most of the time, but it certainly seems to be envisaged by the Act. Again, I don't think that's something you need to decide for the purposes of these proceedings, but we're certainly not conceding that that's not possible. Then let's look at the conclusion, which is at paragraph 78. So what we see in the conclusion is that in the case of section 26, the term person can expressly extend to the undertaking. So pausing there, yes, it does expressly extend to the undertaking. But, the court goes on to say, that does not absolve the CMA from directing the section 26 notice to a specific natural or legal person within the undertaking, provided the notice makes clear, and the clearer the words, the better, that the notice is directed not merely to the addressees but to the undertaking as a whole, then it seems to us that the following is the case. I think the tribunal here I think that's correct. They're saying you can direct it to an undertaking, but one of the convenient legal pegs to bring it to the notice of the undertaking might be a specific legal person within the undertaking.
On the basis that they're an agent of the undertaking, as employees,
yes,
or agents of the undertaking.
Yes, exactly, my lord, exactly, it's precisely so. And then the tribunal. Then let's look at what the tribunal says next. So they say, subparagraph. Let's go over to subparagraph. Well, let's take it in turn. So subparagraph 1. Suppose a section 26 notice is served on U1 but is clearly addressed to the entirety of the undertaking. U1 would be obliged to provide to the CMA the documents and information responsive to the notice in its own control, including those documents held abroad and via controlled subsidiaries. This follows from the fact that the notice is addressed inter alios U1, so we agree with that. Then 2, additionally, U1 would have to notify the rest of the undertaking of the notice. And then, interestingly, the court says this is not as onerous as it seems, because as we understand it, it's standard practice for the CMA to require persons in the position of U1 to provide this information anyway. If in the specific case the requirement is onerous, we'd expect constructive dialogue between the CMA and U1. Well, that seems, apart from anything else, that cuts across the not onerous. We agree it's not onerous, but it cuts across the interorum point that the tribunal made earlier, which is throw up your hands, it's an undertaking, we don't know what's in it. But in any event, we disagree that U1 has to then formally notify other parts of the undertaking, because once the undertaking is notified by the CMA, that's all that the CMA needs to do. Of course, what it does internally is a matter for it, but there's no obligation on the CMA to ensure that that happens. It's not necessary because the undertaking is a unit of account by itself. Then at 3, notice to U1 would be sufficient to trigger an obligation to respond in U2 and U3 because they have a UK territorial connection. The same would not be the case for U4 or U5 because they don't have a UK territorial connection. To oblige them to respond to the notice would be to give Section 26 extraterritorial effect. Now, the problem is that once you accept, the reason that this is wrong is once you accept that a response, there's an obligation to respond in U2 and U3 because it's part of the undertaking and the notice applies to the undertaking, there simply is no basis in the Act. The reason that that's accepted is because the undertaking is a unit of account by itself, it's a single person. But once you accept that, there's just no basis for hiving off U4 and U5 because they're part of the very same unit. That's the error there. And then you see...
Again, it also completely overlooks or ignores the Section 25.
It does, yes. It overlooks Section 25.
Because the case is that this is all on the hypothesis that the CMA has reasonable grounds for suspecting that there is an intention to affect competition within the United Kingdom.
That's right. So that the powers can only be exercised within those bounds. It's being exercised within those bounds. Plainly, we know that undertakings outside the jurisdiction can be responsible for breach of the substantive provision. By the court below accepting that U2 and U3 are fixed with the obligation as being part of the undertaking, they've accepted that the undertaking is to be treated as a single person. Yeah. But then they say, oh, but we're going to ignore that for the purposes of U4 and U5, and we can look beyond the single unitary person and start unpicking what the constituent elements are. And that is wrong, and just internally doesn't stack up in terms of logic. And then then we see, moreover, what the tribunal's contemplating here, we see, is an obligation on U1 to serve the notice on U4 and U5, even though the notice would be wholly ineffective on the tribunal's reasoning to them. And we say that that's an absurd result, and it's not. Which no party, as I showed you, no party seems to be seriously contending for. So that's the part of Mr. Kennelly's skeleton I took you to at the outset, where they accept that isn't a proper construction of the Act. And then paragraph 79 really encapsulates this reasoning and is wrong for the reasons I've given already. So that's what we say about the judgment. It starts by, first of all, it dismisses our, what it calls more muscular arguments summarily without reasons. And on our argument on undertaking, it accepts that Section 59 correctly means that any person includes undertaking, but then proceeds wholly to undermine that by divvying up the undertaking, which completely defeats the purpose of treating an undertaking as a unitary person. So I'm going now to draw together our submissions. I think I can do this quite quickly. Grounds 1 and 2 of our appeal raise a single question of statutory construction. What is the meaning of any person in Section 26? As I've said, there's no express territorial limitation on any person. But what one does have in the Act are deliberate territorial provisions in the substantive provisions and Section 25, which show that Parliament's given thought to the territorial ambit. And stipulated what the territorial ambit is of A, the substantive provisions, and B, the investigatory powers. And Section 26 is an investigatory power. As I've said, Section 25 by itself doesn't achieve anything. So the question for the court is whether, despite that, a territorial limitation arises as a matter of implication as a result of the presumption against extraterritoriality. I've taken you to KBR. There are diminishing returns in referring to authorities because this is a matter of statutory construction which turns on the particular statute. But may I just take you briefly to 3 more? The first is Black. I'll take you to that very, very briefly. That's in, I think, volume 3 of your authorities, tab 51.
correct. You're getting good at this.
Sorry?
You're getting good at this.
Yeah.
It is tab.
It was my task over lunchtime. And this concerned the circumstances. So this concerned a different presumption, a different rule of statutory construction. It's of assistance on the circumstances in which a rule of statutory construction consisting of a presumption can be rebutted by necessary implication. And the presumption in that case was that a statute doesn't bind the Crown. And can I just take you, please, to paragraph 36 on page 1058. Because this sets out the proper approach, we say, to rules of construction that comprise presumptions and the rebuttal of presumptions. And you see that the goal at 3, the goal of all statutory interpretation is to discover the intention of the legislation. That intention is to be gathered from the words used by Parliament, considered in the light of their context and purpose. A necessary implication is one that necessarily follows from the express provisions of the statute construed in their context. And then in considering the intention of the legislation, it's not enough that it's intended for the public good or that it would be even more beneficial for the public if the Crown were bound. However, it's not necessary that the purpose of the legislation would be wholly frustrated if the Crown were not bound. The purpose, one very important, if you look at the end of the page, purpose of the Act would have been frustrated. And so it's sufficient if one's looking at the circumstances in which a presumption may be rebutted, it's sufficient if the application of the presumption would frustrate one important purpose of the Act. And of course, we've got all of our points on the express language of the Act, but we also say that a very important purpose of the Act would be frustrated if the presumption against extraterritoriality were to apply as contended for by the respondents. So that's the first case. The second is Clark, which is in volume 1 of the authorities, tab 28. Now, this case concerned a company not resident in the United Kingdom, but which carried on some business in the United Kingdom. And its employees were carrying out, the employees of the company were carrying out their work outside the jurisdiction. They were paid under contracts not governed by English law and in US dollars, but it was common ground that they were subject to UK income tax. And the issue was whether the company was obliged to deduct tax at source under the PAYE legislation, or whether that involved giving the legislation extraterritorial effect. And we take from this authority 3 propositions. The first we've traversed already. It's that the presumption against extraterritoriality is a rule of construction necessarily sensitive to context and purpose. The second is that mere presence within the UK, no matter for how short a period, is sufficient to attract the application of UK legislation. There's no need for residence. And the third is that the express territorial application of a substantive provision, in this case a charge to income tax, is a factor of significant weight in determining the territorial scope of a procedural provision, in this case the obligation to deduct tax as PAYE. So those are the propositions we take, and let me just show you briefly where we find them. So if we go to the speech of Lord Scarman at bundle page 350, so at letter E, you see the first of the first 2 propositions. 2 points would seem to be clear. First, the principle is a rule of construction only, and secondly, it contemplates mere presence within the jurisdiction as sufficient to attract the application of British legislation. Then we see at F, the Income Tax Acts impose their own territorial limits. But in the absence of any clear indications to the contrary, it doesn't necessarily follow that Parliament has in its fiscal legislation intended any territorial limitation other than that imposed by unenforceability. And then if we go to 353 of the bundle, and we look at C to F, so Schedule E contains the territorial limitations upon the charge to tax. The only question is to determine in what circumstances the tax may be collected by PAYE. This question can be answered by invoking an old principle, even though today it has a new name. The tax presence for which the Crown contends signifies no more, no less than the foreigner in question has, by coming into this country, made himself subject to UK, United Kingdom jurisdiction. My Lords, it's been repeatedly and correctly asserted in argument that this appeal is not concerned with the charge to tax. Indeed, it's conceded that the income, tax upon which the revenue seeks to collect by PAYE, is chargeable under Schedule E. Residence of the taxpayer is, of course, one of the factors determining chargeability to tax. But the present case is concerned with the territorial limitation to be implied into a section which establishes a method of tax collection. The method is to require the person paying the income to deduct it from his payments and account for it to the revenue. The only critical factor, so far as collection is concerned, is whether in the circumstances it can be made effective. A trading presence in the United Kingdom will suffice, and the trading presence was made out on the facts of that case. And then we see Lord Wilberforce's speech, 357D, who it is to be asked is within the legislative grasp or intendment of the statute under consideration. The contention being that as regards companies, the statute can't have been intended to apply to them if they're non-resident. One asks immediately, why not? And of course, we ask the same question in the present case. So that's Clark. The final authority I want to take you to is Gorbachev and Guriev. That's in volume 4 of your authorities, tab 62, a recent judgment of this court. Lord Justice Mayles gave a judgment with which the other members of the court agreed, and it concerned the question whether Section 34 of the Senior Courts Act permitted the claimant to seek third-party disclosure from a person outside the jurisdiction. We can see that from page 1359 of the bundle, paragraph 44. And the reason that I'm taking the court to this authority for two reasons. First of all, because it shows that the strength of any presumption against extraterritoriality varies according to context. So that's before you even get on to rebuttal. It may be stronger or weaker depending on the context. And the second is it discusses the case of McKinnon, which is relied on by my learned friends. So if we look at paragraph 45, the court there makes the point with which we agree, of course, that it's necessary to bear in mind that even broad statements of principle at appellate level must be understood in the context of the issues arising in the particular case. And then paragraph 47 talks about the slipperiness of the concept of territoriality. And we see what's meant by that if we go to paragraph 49 and onwards. So 49, the principle therefore is that legislation does not generally apply to persons and matters outside the jurisdiction, but Parliament may and sometimes does provide in express terms that legislation is to apply to persons anywhere in the world. And we say that's what it's done here, within, of course, the limits expressly stated in Section 2 and Section 18 and Section 25. Equally, it may appear by necessary implication from the language or from the object or subject matter or history of the enactment that it's intended to have such application. Again, we tick those boxes too. The legislation was enacted with the wood pulp principle in mind. Whilst the concept of a person is relatively straightforward, the Benyon formulation does not explain what's meant by a matter within or outside the jurisdiction. It leaves open the possibility, however, that although a person may be outside the jurisdiction, the relevant matter with which the court is concerned may properly be regarded as within the jurisdiction. In such a case, it seems to me that any presumption against extraterritoriality has less force than would otherwise be the case. That illustrates perhaps what Lord Nichols meant in quark fishing by the slipperiness of the territoriality principle. And again, we rely on that proposition because this is a case where persons may be outside the jurisdiction, but they're doing something which is properly, according to the terms of the Act, a matter within the jurisdiction, i.e. Distorting competition within the jurisdiction. Now, McKinnon is a case relied on by my learned friends, and let me just show you what's said about that. We can pick it up at 1364 at the bottom of the page. And McKinnon concerned a power of a court. So we can see at 65 that there was an American bank. The claimant sought an order under Section 7 of the Bankers' Books Evidence Act, which enables a court to order inspection of any entries in a banker's book for the purpose of legal proceedings, requiring an American bank with a branch in London to produce books and papers held at its head office in New York. Because the bank could be served at its London branch, there was no issue about the English court's jurisdiction over the bank. Mr. Justice Hoffman noted that if there had been no London branch, the only ways in which an order could have been obtained for the production of such documents would have been by way of letter of request to the courts of New York. He held that although the English court had personal jurisdiction over the bank, it didn't have subject matter jurisdiction. And if you look at the citation of the excerpt, in principle and authority, it seems to me that the court should not, save in exceptional circumstances, impose such a requirement upon a foreigner, and in particular upon a foreign bank. And if one goes back to the McKinnon judgment, you'll see that the fact it was a bank and the specific obligations on banks was of significance. And then what we see is that if we go down to paragraph 68, it's fair to say that the principle of territoriality appears to have been applied in this case, not as a principle of statutory interpretation affecting the scope of Section 7 of the Bankers' Books Evidence Act, but rather as a powerful and ultimately decisive factor going to the court's discretion. There is perhaps some tension between saying on the one hand that the court didn't have subject matter jurisdiction, and on the other hand that production of documents abroad could be ordered, and in an exceptional case, a court either has jurisdiction or it does not. But the overall thrust of the judgment is clear. It's clear also that the availability of the letter of request procedure and the need to avoid circumventing the methods for obtaining documents prescribed or permitted in the Hague Evidence Convention were important considerations. So that last point is a point which is similar to the point in KBR about the legislation laying down alternative means for obtaining information. And just finally, if we go to...
Is that a very polite paragraph saying that in his heart of hearts he disagrees?
I think it is. I think it is. And one can see why the court's saying there that they disagree, because the reasoning is the court doesn't have subject matter jurisdiction, but in an exceptional case we could make the order, and that really isn't consistent. And then just to show you where this particular case goes, if we pick it up at paragraph 84 on page 1370, internal page 33, the court finds in this case, the Gorbachev case, that in the circumstances of that case, so we can see in 83, the critical fact is the documents whose production is sought are located in England, even though the trustees were outside the jurisdiction. In such circumstances, the principle of territoriality has little or no application. To require the production of documents located within the jurisdiction doesn't involve any illegitimate interference with the sovereignty of the state where the owners of the documents are located. To the extent there's any interference at all, that the interference is legitimate. So that's where, on the facts of the case, it ends up. And over the page at 88 to 89, you see the conclusion. I would therefore hold that Section 34 of the Senior Courts Act allows an application to be brought against a third party out of the jurisdiction for an order to produce documents which are located within England and Wales. I see no difficulty in interpreting the words any documents as referring to any documents present in England and Wales. And then the court goes on to say that conclusion makes it unnecessary to decide whether the court would have jurisdiction to make such an order if the documents have been located elsewhere. There are two views on this, and the two views are set out. And then at 90, you see the court leaves that question to be decided in a case where it makes a difference. So just on McKinnon, we say that great care is needed in attempting to apply the reasoning on judicial discretion in McKinnon to a statutory power of the type that we have in the present case. And if the reasoning in McKinnon were applied to Section 26, it would mean that a foreign company with an office in the United Kingdom could evade investigation of its own breaches of competition law in the UK by squirreling the documents away and leaving them with a subsidiary or a parent company in another jurisdiction, and we say that that's wrong. Now, I'm not going to take you to it, but also in the bundle, lest it be said that I've not taken you to it, is the recent Supreme Court judgment in Maroof, which finds that the presumption against extraterritoriality was not rebutted in the case of the public sector equality duty. I'm not taking you to it because the statutory context is very different to the present, and the principles laid down don't materially add to those in KBR that I have shown you. The court made clear in that case that the presumption's not confined to cases where international law would be breached, hasn't been watered down, and we accept that. So we accept that the presumption is there, but we say that it doesn't arise with any force, if at all, in the present case, and if it does, it's rebutted because of the express meaning of the words and the purpose of the Act. So as I've said, and this really is the now drawing threads together in conclusion, the CMA's case on this appeal is that, first of all, the presumption against extraterritoriality is attenuated in this case. It applies with much less force than in other contexts. And secondly, it is rebutted. And there are 5 critical features of the statutory scheme in this regard. The first is that the statute expressly permits the CMA to compel documents and information from an undertaking. An undertaking is not territorial in nature, as the tribunal correctly found. That would have been as obvious when the 1998 Act was passed as it is now. And so Parliament accordingly expressly conferred power on the CMA to compel documents from undertakings, from entities, which may be outside the jurisdiction. Now, one can debate whether this point is relevant to the strength of the presumption or to the rebuttal of the presumption or to both. We say both, but it doesn't really matter. An undertaking is a single person, and if it's brought itself within the jurisdiction as a single person, then in our submission, giving a notice to an undertaking doesn't entail any material extraterritorial effect. And as the court held in Gorbachev, the presumption applies with much less force in that context. Further, the presumption is rebutted by express wording in the Act, namely, the power under Section 26, read in accordance with Section 59, to compel documents from an entity, the undertaking, which is not territorial in nature, and which Parliament well knew would be likely to straddle different jurisdictions. That's the first point. The second point is that the substantive powers and the investigatory powers of the Act are expressly extraterritorial in their scope. And as we've been discussing, Parliament has conferred in Section 25 of the statute powers of investigation where the CMA suspects an infringement of the substantive provisions, powers of investigation to investigate breaches of competition law that take place abroad which are implemented in the UK. That's expressly said in Section 25. So Parliament has turned its mind to the territorial scope both of the substantive provisions and of the investigatory powers.
Can I just ask you this? You said that we should rebut, the presumption's rebutted. I'm just trying to work out analytically whether the first question is whether Parliament, as it were, occupied the field. So there's no question about having to even consider an evidential presumption either way. Is that right, or is it only if there's an ambiguity and you're not certain you have to then apply various factors to see whether or not the presumption applies or not?
No, I think that the correct analysis is that there is a rule of statutory construction in general which comprises a presumption against extraterritoriality. So
does it apply if Parliament has addressed its mind to it and, as it were, provided its answer in black and white terms?
So
Never get into the presumption.
I think one can look at it in. It's a very good question, perhaps an existential question for this. But I think the way I would answer that question, my lord, is as follows. So, I'd make 2 points. The first is that we say that the presumption, if it exists at all, is very attenuated, and that is precisely because, as you've said, my Lord, Parliament has addressed its mind to these points. So this is legislation where Parliament has said has extraterritorial effect, and as you've seen, other jurisdictions proceed in a similar way. And so the presumption is attenuated, and that's really the point in Gorbachev, that the strength of the presumption varies according to context. So we say if the presumption arises at all, it arises weakly in this case. And one of the reasons why it may not arise at all, or arises very weakly, is because of the undertaking point, that Section 26 applies to undertakings, and undertakings are, and Parliament well knew, international in their scope. And so Parliament expressly, and where you have an undertaking that's here, then it has entered the jurisdiction. It's to be viewed as a unit which is here, even if constituent parts of it are outside. That doesn't matter, because it's to be regarded as a single person which is here in the UK. And so in those circumstances, the presumption doesn't really arise because the undertaking is present in the jurisdiction. But if the presumption does arise, then we say it's rebutted. And what's clear from the case law is that a presumption can be rebutted by express words, and that's what makes me think that you do sort of start, in a sense, with a presumption. So it is legitimate for the respondents to say there's a presumption against extraterritoriality, is it rebutted? Because where Parliament uses express words, and this is a point made in KBR, so where Parliament says this is going to have extraterritorial effect, Parliament has rebutted the presumption by the express words of the statute. Now, we have express words here, you don't need express words, and that's really the point made in Black, that if the rebuttal can arise through implication, the implication being that if a core or important purpose of the Act is going to be frustrated, if the presumption's applied, then it's rebutted on that basis. So the second point is the point I've made about the express words of the Act, Section 2, 18 and 25. You've seen from Arlberg Portland, and it's common sense in any event, that the investigatory powers, the specific investigatory powers, notably Section 6, are of critical importance in actually rendering these substantive provisions and any investigation effective. How does the CMA investigate if it can't obtain documents? And it would be very odd if, having conferred the power of investigation on the CMA under Section 25 to investigate breaches that happen abroad but are implemented in the UK, Parliament didn't provide the CMA with any means of actually conducting the investigation. And so to construe Section 26 in a way which didn't allow the CMA to exercise its power under Section 25, we say would be wrong. It would frustrate the Act, and it can't be what Parliament intended. Thirdly, the investigatory powers in the Competition Act, including notably Section 26, are the only powers that exist for the investigation of breaches of Sections 2 and 18. And by contrast with the position in KBR, there are no other statutory means through which the CMA can obtain information. What one doesn't have in this sphere are the network of international treaties and cooperation which require foreign competition authorities to provide information to the CMA. And that was, as I took you to, a very important indicator in KBR why the relevant provisions of the Criminal Justice Act did not have extraterritorial application. Fourthly, again, by contrast to KBR, the Act contains safeguards in relation to the power. So information must be gathered for the purpose of the Section 25 investigation, which will have a UK territorial connection. Improper disclosure of information gathered under Section 26 is a criminal offence. There's a right of appeal on the merits to the tribunal against the imposition of a penalty under Section 114 of the Enterprise Act. That appeal has suspensive effect. Even if it fails, the obligation to pay the penalty can only be enforced by civil proceedings before a court. See Section 115 of the Enterprise Act. If a person is outside the UK, leave to serve out will be required, and enforcement will likely be against a debtor's UK assets if it's not present in the UK. Fifthly, this is not a case in which exercise of the power offends notions of comity, and I've made that point already. I've shown the court that the Commission exercises a similar power as do the EU member states in relation to material that lies outside the jurisdiction of the EU. And so drawing those points together and encapsulating them, translating them, as it were, to use a phrase of the tribunal, into our grounds of appeal, the CMA's case is that these features of the statutory scheme result in a finding that the presumption, if it exists, is attenuated and in any event is rebutted, and that any person in section 26 means precisely that. The presumption is rebutted expressly by section 59 and by the territorial scope provisions in section 25 and sections 2 and 18. And it's also rebutted by implication because an important aim of the Act would be frustrated. So that's our ground one. And in any event, as concerns the position of these respondents, the presumption is rebutted by the express words of section 59 because they are part of undertakings present in the United Kingdom who have brought themselves within the application of a UK statute. And that's the point, that undertaking is a unitary person. The undertaking is here, they're within the jurisdiction of the UK, and it's illegitimate to do as the tribunal below did, which is then to salami slice the undertaking into different legal persons. That defeats the point of section 59. So, my lords, those are my submissions. If there's anything further I can assist you with,
I was
please
trying
let
to
me know.
find in the Cat's judgment, or the High Court Cat judgment, is there a single paragraph or sentence in which the court encapsulates why it says any person can't include an undertaking?
No, it says it can include an undertaking. So it says it gets it right up to that point, we said.
Where's the essential error? Which is the paragraph or sentence which contains the central error in its interpretation of the Act?
So 77 and 78. So 77 and 78 contain the errors. So the tribunal correctly finds that section 59 applies. So they rejected the respondent's argument that you somehow overlook or disregard section 59. So they agree that any person means undertaking. But then what they say, and this appears from paragraph 77 and 78, is that you then have to salami slice the undertaking. Where you don't do it, it says, for bits of the undertaking that have a UK territorial connection, they're fine. That's U2 and U3. You see that at...
So where's the salami slicing point? I'm actually looking for where are the words which really encapsulate or articulate the error in your case.
So
we've got all the U's examples, U1s, 2s, 3s and 4s and 77.
So it's 79. That's
really where they start falling into errors. It's the analysis that begins at 72 in the context of the U example. That's the salami slicing, because you say there is only one U.
There is only one U.
There's only one U.
Exactly.
And so this sort of U1, U2, U3, U4, U5 is just misconceived.
Misconceived.
That's where they go wrong.
That's where they go wrong. And it's actually encapsulated.
It's downhill all the way after
It's
that.
downhill all the way. And it is encapsulated in paragraph 79. If we just go to that, because I didn't read it out and I should have done. So this approach respects, so the approach up to that point respects the extended meaning of person in section 26, such that a section 26 notice can be made to an undertaking, but only via a natural or legal person with sufficient connection to the jurisdiction. Provided the notice is clearly addressed to the undertaking, there's an obligation to inform all constituent elements of the undertaking of the notice. Whether those constituent elements are themselves, this is really the error now, really getting to the root of it, whether those constituent elements are themselves obliged to respond to the notice depends on whether considering their status as natural or legal persons and disregarding their position as part of an undertaking. So again, those words, disregarding their position as part of the undertaking, that totally defeats the earlier finding that this all applies to undertakings. They have or do not have a UK territorial connection. If they do, then they must respond as if the notice were directed to them specifically. If they do not, then the presumption against extraterritoriality applies and there's no obligation to respond. So there are lots of things wrong with that. The first is the point that my lord put to me, which is the undertaking. They found correctly that any person is undertaking, but then they ignore the unitary nature of it. So that's the first thing that's wrong.
Well, the undertaking, I mean, on the tribunal's own finding,
Yes.
the undertaking is present within the jurisdiction because it has, because of the UK companies. In
Exactly.
each case. But it goes further than that, because this is your muscular ground one point, which is that even if there weren't a UK subsidiary in each case, the undertaking was still, there would still be a territorial presence by virtue of the alleged infringement of Section 25. Section 25.
That's exactly our case, and the tribunal obviously hated the muscular approach and didn't really gave it very short
But
shrift.
they didn't analyse Section 25 at all.
They didn't. And on the less muscular approach, what they've done is they've arrived at this odd halfway house, if I can put it that way, where they say, yes, we accept it's an undertaking, but then you've got to look beneath the undertaking and pull it apart depending on the territorial connection of the constituent bits.
In your case, you say that an undertaking is legally indivisible.
Yes.
There may be many ways in which, for practical purposes, you need to focus on a natural or a legal person, but conceptually it's indivisible in the Act. And the tribunal is saying yes, but no. It is indivisible, but actually when it comes to enforcement, it becomes divisible.
My lord, that's exactly our case, and that's exactly the flaw.
And I think possibly it's the second half of the first sentence of 79, but only via a natural or legal person with sufficient connection to the jurisdiction. Because the first half is fine.
Yeah.
But then they add the caveat, but only, which presumably is a point of law, through a natural or legal person, and then with a sufficient connection to the jurisdiction.
Yeah, so that's about giving notice, and we say that's wrong. And then they talk about, when you then go down to the actual obligation to respond, they then say whether these constituent elements are themselves obliged to respond to the notice depends on whether they have or don't have a UK territorial connection, and that's just wrong.
So the first part is the power to issue the notice, the second part is the duty to respond.
Yeah, and it's not clear, to be fair to the tribunal, it's not clear in different parts of the judgment. That first bit, it's not clear whether it's saying the territorial connection bit is obviously wrong via a natural or legal person with sufficient connection to the jurisdiction. That's wrong. But if they're saying, well, as a matter of practicality, you draw the notice that you're directing to the undertaking you may draw it to a natural or legal person within the undertaking. There's no problem with that. That's a matter of practicality. But they then divide up the undertaking, considering their status as natural or legal persons and disregarding their position as part of the undertaking. That's really, if I had to encapsulate the flaw in one part of one sentence, that's it. Because they've said the undertaking matters, and then they say you disregard the undertaking and you look at the territorial connection, which again is a loose, imprecise phrase, contrary to what's said in KBR. But you salami slice up the undertaking depending on its territorial connection, and it's even more illogical than that, if I can say that without sounding disrespectful, because in paragraph 77 and 78, they're saying that when you serve this notice on U1, you're serving the undertaking. U1 has to tell U4 and U5 about it. The tribunal finds an obligation to tell U4 and U5.
That flows from the analysis is divisible.
Yeah, but then they say, well,
U4... As you say, notification to what? To X is notification to everybody within the undertaking.
Precisely, and then they say, well, you've got to tell U4 and U5. Well, that's wrong. But then they say U4 and U5 don't have to reply. But that seems bizarre because
illogical.
Yeah.
It is about divisibility, isn't it?
It is about divisibility, and it's about Parliament. That's why I took you to RVL, because it's about Parliament deeming that this is a person for the purposes of the Act.
Right. Anything else? Thank you very much.
Thank you.
I suggest we have a break. We don't have a 5-minute break. Have a break. We assume that you've agreed some sort of division between yourselves, and that you're not going to simply repeat each other.
Not at all. I'm dealing with ground 1. My friend Miss Abrams dealing with ground 2.
Thank you very much, Ms. Key. That's very, very helpful. 5 minutes in, please.
All right. Oh no. So on the readings, so flows. I just wonder. I was already
No, it's not going to be.
So I think I want to say yes, it's read across. It's read across, and either that means that. So either it's not read across, and so undertaking doesn't come across, or it is read across, but that doesn't attach to the position that as under EU law for any other final decision, it has to be addressed for any non-person. So take the focus away from the precedent.
Yes.
Yeah, I mean, I have to feel my way about whether I really just make any arguments at all about it, because it's obviously just, they've obviously just decided that, and there's no, I just don't see that I'm going to be able to move them. That section 28.4 point is quite a good point. The section 40 point is also quite a good point. Solicitors chasing me to come back to them on things even though they know I'm in court. How is this?
No, thank you. I'm full of chocolate.
The rule they transfer is actually really tiny, so we didn't literally.
Excuse me. Sorry, do I have this mark on my box or can I be down here?
Oh, you can go down there.
Okay.
Yes, I do.
Guys. Just so you know, Mr. Kennedy, we have to rise at 4:15 today.
In other words, as I indicated before we rose, Volkswagen and BMW are responding to the appeal jointly. I will address the court, if I may, on ground 1.
Yeah.
And my friend Ms. Abram will respond on ground 2.
Mm-hmm.
And it's important to take these grounds separately.
Mm-hmm.
And my friend, Ms. Mitriou, did at times mix them up, but it is important to distinguish them. They are separate questions of law and need to be addressed separately. And you will hear in our response that our case on Section 25 is that Section 25 of the Act is coterminous with Section 2. But our case is that it is not coterminous with Section 26 in terms of its territorial scope. And I'll develop that when I come to the statute. But whether, and that goes to the question of whether it's been addressed expressly, whether the extraterritorial power is given expressly or implicitly. As my friend quite correctly accepted just before she finished, the presumption against extraterritoriality has to be addressed. It arises whether Parliament has dealt with it expressly or implicitly. The point that my Lord Justice Green raised and my own friend Mr. Mitriou answered very fairly. It arises in either case. And so in dealing with ground 1, I propose now to summarise very briefly our case and then return to KBR in the Supreme Court. I'll go back to Gorbachev and Guriev and very briefly to Maroof, because as again my own friend Mr. Mitriou said, much of the authority is summarised in the most recent cases. There's no need to go through all of the cases again. And then I will turn to the provisions of the Competition Act. I'll deal with her submissions on the statutory context. And finally, I'll address the factors which the Supreme Court said in KBR have to be addressed in deciding whether or not the presumption is rebutted. Yeah. Now, in summary, on ground one, it is in our submission difficult to imagine a more ambitious claim for implied extraterritorial powers. Because on the CMA's primary case, ground one is their primary case, the words any person in section 26 of the Competition Act apply to all individuals, companies and undertakings, irrespective of their nationality, irrespective of where they are located. And to exercise that power, says the CMA, it does not need to show that the person is part of any undertaking connected in any way to the UK or part of any undertaking under investigation. And that last point is one which my friend rather glided over in her submissions on ground one. She focused, understandably, on undertakings subject to investigation, undertakings accused of wrongdoing. But the CMA's case is that their broad reading of any person applies to anyone, including wholly innocent people who are accused of nothing, but who may, in the CMA's view, hold information of relevance to their investigation. So the CMA claims for itself a power to command, under pain of sanction, the provision of information and documents from any individual, any company, anywhere in the world, even if there is nothing to connect them to the UK and no shadow of suspicion upon them. And such a power would require, in our submission, the clearest legislative language, but that is not what we have here. And I'll come to the statute after KBR. In fact, as I'll show you later, when the government proposed legislation to Parliament to give the CMA extraterritorial investigatory powers in the 2023 Digital Markets Competition and Consumers Bill that my learned friend took you to, the express powers proposed in that bill are less extensive than what the CMA now seeks to imply into Section 26 in this case. And I'll show that to the court when I come to it. And in my submission, the CMA's arguments are irreconcilable with the judgment of the Supreme Court in KBR, because there is nothing in the scheme, context or subject matter, that displaces the presumption against extraterritoriality. In fact, the relevant contextual factors, which I'm afraid were not developed in detail before you, strengthen the force of the presumption. But to make that good, I do need to go with some care through KBR. My own friend took you to it, but skipped certain parts. It's of critical importance to understand the nature of the presumption and how it operates in a very analogous context. And that's, in the, I think, the fourth volume of authorities that the court has, behind tab 59. This case is particularly useful because in it, the SFO argued not just that its investigatory powers should be given extraterritorial effect, but to support that argument, the SFO pointed out that the substantive prohibition it was seeking to enforce had extraterritorial effect, just like Section 2 of the Competition Act in this case. And just to track that through, if you go please to page 1258, 1258 of the bundle, and paragraph 2 is of the parties to the investigation. You see that KBR Inc. and the issue was whether KBR Inc. could be required to respond to the notice, is incorporated in the United States. It was subject to investigation by the DOJ and the SEC in an investigation into the affairs of Una Oil, a Monaco-based company in relation to international projects involving several global companies, including KBR Inc., whose interactions with Una Oil were a subject of those investigations. And then 3, KBR Inc. has UK subsidiaries, including Kellogg Brown and Root Limited, which was under investigation by the SFO. The investigation was related to the SFO's ongoing investigation into the activities of Una Oil. And that investigation is described in a different authority concerning Una Oil in this bundle. If you could go to please to bundle 3 for this. Sorry, different bundle for you. Bundle 3, tab 50. So keep KBR open if you can, and go to tab 50. This just tells you.
Court.
So sorry.
This is the divisional court.
It is the no. It's actually it's
Another divisional court.
Indeed. It's not the case from. It's not the divisional court judgment
Yeah, okay.
which led to the appeal in KBR, but it tells you about the investigation. I'm just taking you to show you the investigation, and that's on page 1029. This was the root of the investigation into KBR, and it's on paragraph 5. You see that in 2016, this was the SFO commenced an investigation pursuant to section 1.3 of the 1987 Act, and it's because the SFO suspected that offences had been committed, and it lists them, but I draw the court's attention at C to the conspiracy to enter into corrupt transactions outside the UK, and this in particular, the offences of bribery under sections 1 and 6 of the Bribery Act 2010. Because KBR was also under investigation for involvement in foreign corruption and bribery. And to see how the substantive prohibition works, the substantive prohibition that was an issue in KBR, we need to go to the Bribery Act itself, which is in the authorities, it should be in your authorities 1, behind tab 13. It's missing section 1 of the Bribery Act, despite the fact that this is part of what Dr. Sedley's thing about bundles. You have loads of them, but they don't actually contain the things you actually need to see. This is such an example. Section 1 of the Bribery Act, I need to give it to the court and slot it in at the beginning. It's the Bribery Act is in tab 13 in your first authorities bundle. So looking at section 1 of the Bribery Act, which I've just given you, in fact, you can put it at the beginning of tab 13. And you see the offence of bribing a person P is guilty of an offence if either of the following cases applies. I ask the court to go only to case 1. That's where P is promising or offering a financial or other advantage to another person and intends the advantage to induce that other person to perform a relevant function or activity. And if you go to subsection 5 over the page, you see in cases 1 and 2, it doesn't matter whether the advantage is offered, promised, or given by P directly or through a third party. If you go on, please, in the same Bribery Act to section 12, you see the territorial application of these offences. And section 12, subsection 1, an offence is committed under section 1 or 6 for my purposes if any act or omission which forms part of the offence takes place in that part of the United Kingdom. So if any part of the act or omission takes place in the UK, the offence is committed even if the other parts take place outside the UK. So based on the offence under section 1 that you've seen, it could arise where a US company intended to bribe a foreign official, say in Kazakhstan, as happened in KBR. And that promise of an advantage is communicated via a person in the United Kingdom. So in those circumstances, the US company commits an offence which can be punished in England. The US company may be prosecuted here. And that, in my respectful submission, is very like what we see in section 2.3, a foreign cartel, which is implemented in the UK. The implementation is a necessary part of the prohibited conduct under section 2, even if the proponent of the conduct is entirely outside the United Kingdom. The implementation is part of the prohibited conduct. In fact, implementation may be a more tangential link. Sorry, the use of a UK conduit may be a more tangential link than the implementation of a cartel directly into the UK. But in the Bribery Act, it suffices to give the extraterritorial jurisdiction to the offence of bribery. And just to see how Parliament does deal with it expressly in a different context, still in section 12, see section 12, subsection 2, subsection 3 applies if no act which forms part of the offence takes place in the UK. B, that a person's act or omission outside the UK would form part of the offence if done in the UK, and that person has a close connection with the UK. Subsection 3, in such a case, the acts or omissions which are outside the UK are treated as if they form part of the offence, and proceedings for the offence may be taken at any place in the United Kingdom. So overall, under the Bribery Act, the SFO can prosecute a foreigner for wholly foreign conduct if that conduct touches the UK in a relevant way. We have that under section 12.1. That's, for example, the use of a UK conduit or participant in the scheme. Or you can prosecute someone with a UK connection abroad. Sorry, you can prosecute a UK connected person who is abroad for conduct wholly abroad, conduct that doesn't touch the UK at all. And the UK connection is defined in subsection 4, a citizen, someone ordinarily resident in the UK, and so forth. So that's the substantive prohibition that was in issue in KBR. And so with that in mind, we go back to KBR behind tab 59. And ask the court to go to page 1256 to understand the understandable reliance that the SFO placed on this. And we have at 1256, this is the argument of Sir James Eadie for the SFO before the Supreme Court. And if you go between G and H on page 1256 of the bundle, the SFO submission was an overseas company can be prosecuted for bribery in the UK if the bribery took place within the jurisdiction under section 1 of the Bribery Act. It would seem to follow that there must be a power to investigate such bribery. Here the SFO understandably is saying the substantive prohibition, substantive offence is extraterritorial. Surely we have the power to investigate it with extraterritorial investigatory powers. Now the CMA seeks to distinguish KBR because they say in a skeleton the SFO's investigatory power and the relevant substantive prohibitions were in different statutes. Now, in our respectful submission, that must be immaterial and it formed no part of the Supreme Court's reasoning, as we will see. It was not suggested, for example, that when the SFO's investigatory powers were created in the 1987 Act, that my learned friend took you to, it was never suggested they were never going to investigate foreign conduct, or that no offences to be investigated by the SFO would have extraterritorial scope. When Parliament enacted the Bribery Act in 2010, it knew that any extraterritorial offences to be investigated by the SFO would be investigated using the powers in the 1987 Criminal Justice Act, which is no doubt why counsel for the SFO said to the Supreme Court, surely where the substantive prohibition is extraterritorial, there must be a power to demand information from overseas companies. If you go to page 1258, paragraph 4, we see what happened in cable. Page 1258 of the bundle, paragraph 4. So the SFO issued their notice under section 2.3 of the 1987 Act to KBR UK. KBR UK provided materials, but it made clear that certain materials not in its possession or control, but if, and to the extent it exists, was held by KBR Inc. in the United States. The very scenario which my friend addressed this morning. And the SFO insisted that at a meeting in London, KBR Inc. should attend not merely by lawyers, but by officers of that company, and officers agreed to attend. And you see in paragraph 5, the General Counsel and Corporate Secretary of KBR Inc. and the Chief Compliance Officer flew to the UK, and at the meeting, they were there in person, senior officers of KBR Inc., and they were handed the section 2.3 notice. They were physically present, albeit in a transient way in the UK, and they were served. Now, if you go to paragraph 14, please. My friend has shown you paragraph 13, because my friend took you to this section 1.3 of the 1987 Act, which confers on the director of the SFO, it's on page 1259, the next page, the power to investigate any suspected offence which appears to him on reasonable grounds to involve serious or complex fraud, and the powers shall be exercisable for the purposes of the investigation only in any case where it appears to him that there's good reason to do so for the purpose of investigating the affairs of any person.
Now, just to be clear, the definition of a person in section 1 of the Bribery Act is just the normal definition in the Interpretation Act. Is it natural or legal person or partnership?
Yes.
So there's no inclusion of undertaking.
No, and as I say, I'm dealing with ground 1, and it's important to recall ground 1 does not depend on any undertaking having any foothold in the UK at all, which is why it's described as the muscular version of the CMA's case, but it's their primary case. And on section 1.3 of the 1987 Act, one sees here the umbrella investigation power, rather like section 25 of the Competition Act. This is the bit that says you can investigate anything that looks like a breach, which you have the power to investigate. And it's drafted in very broad terms, section 1.3. But that was not material in the construction section 2.3, which we now go to, and that is where the words any other person appears. The director may by notice in writing require the person under investigation or any other person to produce at such place as may be specified in the notice any specified documents. And if you skip to paragraph 16, you see section 2.13 provides that any person who without reasonable excuse fails to comply with the requirement under section 2 shall be guilty of an offence. So it was a criminal sanction applicable to a failure to comply. And if you go on please then to paragraph 21 on page 1261, and we have the presumption against extraterritorial effect. Now, I appreciate that much of this is familiar to the court, and my friend took you to part of it. But I'm going to go through it again in rather more detail because of the importance of the presumption, as the courts have found and found repeatedly. If you see in paragraph 21, the starting point is that legislation is generally not intended to have extraterritorial effect. Lord Lloyd-Jones quotes from a speech of Lord Bingham and Alscaney, and I'll skip down to H. Unless the contrary intention appears, Parliament is taken to intend an act to extend to each territory of the UK, but not to any territory outside the UK. This is from Benyon. Unless the contrary intention appears, an enactment applies to all persons or matters within the territory to which it extends, but not to any other persons and matters. And if you skip down to D, on what is now page 1262, Lord Bingham said that there is such a presumption is not, I think, in doubt. And in fact, quoting from Lord Walker in Al Saba, that presumption has become stronger over the years. And it's become stronger, and you'll see this in some other authorities, because Parliament has to a greater extent legislation expressly for extraterritorial effect where it wishes the powers to be extraterritorial. And if you go please then to paragraph 22, Lord Roger and Alscaney, a number of different policies can be seen at work behind the various rules of construction. And every statute is interpreted so far as language permits, so as not to be inconsistent with the comity of nations or the established rules of international law. It would usually be both objectionable in terms of international comity and futile in practice for Parliament to assert its authority over the subjects of another sovereign who are not within the United Kingdom. So in the absence of any indication to the contrary, a court will interpret legislation as not being intended to affect such people. They do not fall within the legislative grasp or intendment of Parliament's legislation. And if you go over the page to page 1263 to paragraph 24, Lord Lloyd-Jones says the presumption reflects in part the requirements of international law that one state should not, by the claim or exercise of jurisdiction, infringe the sovereignty of another state in breach of rules of international law. As, for example, legislation requiring conduct in a foreign state which would be in breach of the laws of that state or otherwise inconsistent with the sovereign right of that state to regulate activities within its territory may well be a breach of international law. And pausing there, Volkswagen made the point to the CMA and to the tribunal that the Section 26 notice in this case may well involve or require Volkswagen AG to breach German data protection laws because such disclosure in Germany requires specific German law safeguards. I'll give you just the cross-reference for your note. It's in our reply in the core bundle, tab 20, page 309. And CMA says, well, that could be a very good defence for a failure to comply with our notice. But that, in our respectful submission, is the wrong approach. The risk of compelling the breach of foreign laws is not something to worry about after the notice is served. In our submission, it goes to the scope of the legislative power. It explains, in part, why the presumption against extraterritoriality stands. But if we go on in paragraph 24, however, the rationale and resulting scope of the presumption are wider than this. Of course, it doesn't depend on breaches of international law. They are also rooted in the concept of comity. The term comity is used here to describe something less than a rule of international law. Judge Crawford explains that certain usages are carried on out of courtesy or comity, are not articulated or claimed as legal requirements. International comity is as a species of accommodation. It involves neighbourliness, mutual respect, and a friendly waiver of technicalities. And the learned Lord goes on to explain in paragraph 25 that the lack of precisely defined rules in international law as to the limits of legislative jurisdiction makes resort to the principle of comity as a basis of the presumption applied by courts in this jurisdiction all the more important. As a result, the presumption in domestic law is more extensive and reflects the usages of states acting out of mutual respect and, no doubt, the expectation of reciprocal advantage. Accordingly, it's not necessary in invoking the presumption to demonstrate that the extraterritorial application of the legislation issue would infringe the sovereignty of another state in violation of international law. In the present case, says Lord Jones, we're not concerned with jurisdiction over the conduct abroad of a UK national or a UK registered company. As common ground that if the addressee had been a British registered company, Section 2.3 would have authorised the service of a notice to produce documents held abroad by that company. And that's similarly common ground here. Similarly, we're not concerned with the position of a foreign company which has a registered office or a fixed place of business in this jurisdiction, or which carries on business here. And this is interesting. The addressee of the notice, KBR Inc., has never carried on business in the United Kingdom or had a registered office or any other presence here. And the Supreme Court said that notwithstanding the fact that KBR Inc. had a wholly owned subsidiary in the jurisdiction. And it went further. The attendance by senior corporate officers at the of KBR Inc. at the meeting in London in July 2017, and the fact that Ms. Akerson was served with a notice on behalf of the company, KBR Inc., on that occasion, do not alter this fact. Accordingly, the presumption against extraterritorial effect clearly does apply here. Moving on then to, is the presumption rebutted by the language of the statute? And we see it at 28. Like my learned friend, Sir James Eady for the SFO draws attention to the breadth of the words used in section 2.3. In his submission, the words are deliberately wide. It confers a power exercisable against the person under investigation or any other person and can relate to the production of any specified documents, provided the documents relate to any matter relevant to an investigation. Now, my other friend said we have to read different statutes in their own context, and it's true there are some differences in the Competition Act, but one sees here real parallels with the statutory language in section 26 of the Competition Act. And then going down in the same paragraph to below E, while the breadth of these provisions provides some support for the SFO's case, it's to be noted that when legislation is intended to extraterritorial effect, Parliament frequently makes express provision to that effect, and references are made to the Criminal Justice Act 1988 and the Sexual Offences Act, and then this at F of particular relevance here, given the reasoning of the Divisional Court, is section 12 of the Bribery Act, which we've just seen, which criminalises conduct outside the UK if it would form part of a relevant offence if done in the UK, and if the actor meets one of certain defined criteria, establishing a close connection with the United Kingdom. And then this, upon which I place particular reliance, the more exorbitant the jurisdiction, the more is likely to be required of the statutory provisions in order to rebut the presumption against extraterritorial effect. And in that case, section 2.3 includes no such express provision. And I'd say a fortiori in the case of the CMA's ground 1 and the interpretation it seeks to give to section 26. Any person, anywhere, even if they are in no way subject of investigation or accused of any wrongdoing.
Can I just ask you the consequences if you're right? If you say, I mean, I understand the point that on KBR you say there's no correlation between section 25 and 26. I can see on the facts of that case how that might arise. Can I just take you to the wording of section 25 and 26 and see how KBR would apply? Because in section,
Yes, of course.
and really what is Parliament intending on your analysis here? So in any of the following cases, the CMA may conduct an investigation. So this is power to conduct an investigation.
Yes.
And first, if you look at the permutations permitted under 25(2), it could involve parties who are wholly and exclusively outside of the United Kingdom who have not yet done anything in the UK, because that's what's going to be investigated.
Yes.
So implementation is something they'd investigate, which is under section 2. So you do have a power to investigate something which is entirely without connection to the UK. So it may affect trade, object of. Yep.
Yes.
So then you turn over to section 26. For the purposes of an investigation, and we now add in to to the situation, and we've got to add in reasonable grounds for suspecting. Okay. So for the purpose of investigating a cartel for which there are reasonable grounds for suspicion, the CMA may require a person to produce information. So you're saying that even though 25 contemplates a situation of an infringement with zero connection to the UK at the point in time of the investigation, and because Section 26 empowers them to conduct an investigation, yet they can't.
No, respectfully. They can, of course, conduct the investigation. That's why I said that Section 25 is coterminous with Section 2. They open the investigation. They are perfectly entitled under Section 25 to investigate a
They
foreign
can't issue
cartel.
a notice, request for information.
They can investigate the foreign cartel. They can investigate it to the fullest of their ability. But what they cannot do under Section 26 is order a foreign person to produce documents and information for the purpose of that investigation. Now I see right away.
If the only source of information is that foreign person,
Yes.
I mean, that may not be the facts of this case because the UK companies have provided documentation which may or may not support the CMA case. We're not concerned with that. But let's assume that the only information that would ever be available is from the foreign undertaking. Your case is they can conduct an investigation, but it's absolutely no earthly use whatsoever.
No.
It's a nihil ad rem, say in Latin.
Again, respectfully, no, because they can conduct an effective investigation. True it is that they cannot compel a foreign person to produce documents and information under threat of sanction to be transmitted to the United Kingdom. But what they can do is precisely what the Supreme Court said in KBR, is they can seek to get it via the appropriate channels in the country which has sovereign power over those individuals. Now, we've been saying consistently that it was open to the CMA to ask the Bundeskartellamt, the German competition authority, to exercise its powers to get information that it needs. That's the
No obligation to do so because we're not part of the ECN anymore.
Indeed. But under, and I'll come to this, under none of the mutual legal assistance provisions to which the Supreme Court referred to in KBR, was it said that a foreign sovereign authority was compelled to extract information from its own nationals and transmit it to the SFO. As this court knows very...
KBR.
I'm so sorry.
That was in KBR.
Indeed, in KBR.
Because that's got an entirely different legislative history.
Well,
The case turned on the legislative history. That's the ratio of KBR.
I'll come back to that, my lord, if I may, about the ratio, because it was an important part of the analysis in KBR. But if one looks at the structure of the judgment, the Supreme Court in KBR placed as much weight on the significance of the criminal offence in its analysis of the Perry case. And I'll come to that.
We'll come to that.
I will indeed. I don't deny for a moment that the role of mutual legal assistance was important to the results in KBR, and I'll come back to that. But it's part of my answer to my Lord Justice Green. The way in which regulations deal with the problem of the restrictions on extraterritoriality is to use the mechanisms, or to seek to make and develop mechanisms that respect the sovereignty of other nations. And if I may
the problem with that, something we need to think about, but what Parliament has done here is contemplate a situation of a cartel with zero connection to the UK. Cartels are clandestine.
yes,
They'll go to countries, they'll keep the information. It's not going to be all over the place. It's going to be on a few WhatsApps. Now may not get into an inquiry in next year's time. But it's not easy to get your hands on it. And if you have a regime where Parliament has said, it's a really serious offence, almost the worst sort, people outside target the UK, regulate prices through innocent agents. We just tell them what price to fix.
yes.
And they know nothing about the cartel. We keep all the clandestine documents offshore. And that's the situation contemplated in 25. And then it says in 26, CMA may.
Yes.
I mean, isn't that as extraterritorial as you can get in 25? And then connected to the triggering power in 26?
Not so, because if that were right, my lord, it would have worked in KBR. In KBR, my lord, the court, I see my lord shaking his head.
You're going to get to that solution
I
when we look
will.
at the ratio of KBR.
I will, but
Because it's an odd business to be construing one statute by reference to the result in a case that was looking at a completely different set of legislation.
the legislation, in my respectful submission, was not completely different. The wording of any person in the Criminal Justice Act was very similar. I don't suggest for a moment that it's determinative, but it's very similar, and its vice was the same vice we identify in section 26. But I refer to KBR really to address my Lord Justice Green's point, which is that in KBR, it could just as easily have been said, and it was said, that in an international fraud case involving skullduggery and international bribery, just as in the cartel case, it could be said, wrongdoers will locate themselves in foreign jurisdictions. They will seek to hide their illicit behaviour. In KBR, the substantive prohibition required either a link with the UK or, for the UK connected person, no link at all. So it's very similar to the substantive prohibition in Competition Act.
It is and it isn't. I mean, a lot of corruption is based abroad, and you may have a flow through a bank. I mean, the US founds jurisdiction simply because the money passes through a bank there, and they make vast amounts of money by settling claims and fraud. I mean, and here, under the Bribery Act, you simply have to have one act,
Yes.
which may involve corruption anywhere in the world. One of the differences between the two pieces of legislation is that this is concerned only with a substantive offence which is focused upon the United Kingdom. The entirety of the offence occurs in the United Kingdom and is designed to protect the UK market, not because, Astan or somewhere else in the world. There's quite a difference between the factual premises behind both acts.
I respectfully accept that the offence under the Bribery Act can involve harm done to third parties in foreign countries, whereas the Competition Act is focused on harm done to UK markets in the Competition Act.
I suspect if you look at the SFO's website, the vast majority of their cases involve corruption abroad or bribery abroad.
But my point, my point, my lord, just to my lord's point, is the same though. That distinction really doesn't make a difference here, because the point that you put to me, here we have a substantive prohibition. We have a power to investigate something which may be wholly outside the UK. Surely, the investigatory powers should also be extraterritorial. And I say, not so. That was the same situation in KBR. The SFO made the same plea.
But we understand the point.
But critically to that is the question of practicability. And there are lots of factors that go to this. This is not the only factor that goes to the construction.
And you may be right. I mean, I was just looking at paragraph 21 as to how the presumption against extraterritoriality fits in. Does it only arise if you construe and you only decide if there's room or not? Paragraph 21 might suggest that it is, as Mr. Mitri, I think, sort of accepting that it applies at all stages of the analysis. So perhaps it becomes a more holistic analysis. But you've got to start presumably with statutory purpose and intention and work out what that was.
Of course. But I'm staying in KBR despite the fact that it's deemed a different scheme, because it is obviously high authority on this very principle by reference to what we say is an analogous scheme. But what it also tells the court are the factors that one takes into account in construing Section 26 of the Competition Act. And I'll go on then, if I may, to paragraph 29, the point that my own friend also made, it can also, extraterritorial effect can be implied, and we'll come back to what's required for implication. But then what are the factors that go to rebutting the presumption? And we see on page 1265, C, Lord Lloyd Jones saying, impracticality of enforcement.
Sorry,
I'm so sorry, I'm on page 1265 of the
paragraph 29.
paragraph 29, over the page
Letter C.
at letter C.
Gotcha.
And this is the point that came up several times in exchanges between my friend and the court. Impracticality of enforcement is a particularly relevant consideration in determining whether a statutory provision has extraterritorial scope. Now, it was put by my Lord Justice Green to my friend, well, you know, what's the relevance of the fact that you may not actually be able to enforce these extraterritorial powers? My friend initially said it wasn't relevant, then she said it wasn't relevant here. It is of central relevance. And in fact, even in that Clark judgment from 1993, the House of Lords judgment that my friend took you to just before she finished, that again said in terms that in construing a statute to examine whether or not it provides for extraterritorial effect, one looks to the practicability of enforcement. Parliament wouldn't give the CMA a power if it couldn't be effectively enforced. And so this really is very important in construing. Now we are in the central question of construing the Competition Act. My friend said, I'm going to quote, "It's wrong-headed reasoning to say that Parliament wouldn't have intended to create a power if it couldn't be practically enforced. On the contrary, it is central to the construction exercise which we are directed to undertake." And in our case, as the court has seen, the CMA accepts that it cannot effectively enforce Section 26 against a legal person outside the jurisdiction with no assets in the UK. The court has seen in the CMA skeleton at paragraph 51, they speak only of enforcement of Section 26, a breach of Section 26, against a judgment debtor's UK assets. If a foreign legal person, the recipient of a Section 26 notice, has no assets here, there was no effective enforcement at all. And to return to my Lord Justice Green's point to me about Section 25 and 26, true it is, one could have a regime, we could have a situation where in a cartel, all the participants are abroad, communicating on WhatsApp. In the investigation, there is yet to be established any connection to the UK at all. In that situation, if the CMA were to direct a Section 26 notice to them, where they have no link to the UK at all, it is highly unlikely they will have assets here against which any breach decision could be enforced. So again, it's central to the question of whether Parliament intended the CMA to have such far-reaching investigation powers. And of course, these powers extend, and I'll say this again and again, not just to people who are suspected of breaches, but to anyone who the CMA thinks could assist them in their inquiries.
Nothing in the Act says the enforcement mechanism has to be perfect, does it? I mean, I suppose you're right, they may have no assets. They could get a judgment debt in the UK and then try and force it abroad in Germany.
There's no suggestion, my Lord, anywhere that such a debt could be enforced. And in fact, such a debt...
Anything to prevent them trying.
But, my Lord, if the CMA thought that such a thing could be done, we'd have more than we have currently before you. The CMA knows very well that a judgment debt based on a penal decision taken by a regulator in the exercise of public law powers
It's difficult.
is very difficult to enforce anywhere as a central principle of international law, which is why in their skeleton, the most they say is, very fairly, they say effective enforcement against UK assets only. They say, well, it's possible there might be some form of foreign enforcement.
Yeah.
It's a sentence with nothing to support it. And that's because we have the provision in the passage in ICMRs before you.
Yeah.
You don't need to look at it.
No.
It's the point I just put to you. Your lordships. Going on then to the next dictum of Lord Lloyd Jones, and now just below C, letter C on the same page. And he makes the point, while the intention behind a provision in a statute needs to be ascertained by looking at the statute as a whole, it doesn't follow that all provisions in a statute have the same territorial ambit. And I rely on that, so does my own friend, but I rely on it for a different purpose, which is to say, properly construed, one can have different territorial ambits for different provisions in the Competition Act, which is the point that I sought to
So you
make.
could have a different territorial ambit for a claim against a non-party who you're just seeking information from, as against someone who was an alleged cartelist.
Precisely, my lord, and that's precisely the
How does
distinction.
that help you?
No, sorry. No. Sorry. No, it doesn't help us now, but it's the kind of distinction that Parliament could make in express language, which is the point they've made. When they came to legislate in the new bill, which I'll show you, that's the distinction they made. That's the kind of distinction Parliament can make. But here, they made no such distinction. And what we have is a section which cannot be construed as the CMA proposes because of the consequences, which are, we say, egregious breaches of extraterritoriality, egregious exercise of extraterritoriality. And what can't be done is for the court to try and read into this language territorial connection required where a person isn't suspected of wrongdoing, but no such connection required if you are suspected of wrongdoing. Even if that would be desirable, that would be the kind of illegitimate judicial legislation which has been deprecated in KBR, and my friend took you to that point.
Can I just ask one question? An unworthy thought crossed my mind. There's a power in section 25 and a power in section 26. Would that be relevant to the power? I mean, most of that power is going to be taken up if you meet the conditions in section 25 or 26, then there's going to be very little which is going to prevent the exercise of the power. But you could have all sorts of wholly improper reasons which the CMA had in its mind, vengeance, insider trading, which they wanted to exercise, makes life difficult. Be quite improper to use the power for that purpose. Would that be a relevant constraint in public law terms on the exercise of that may, even if it doesn't construe the provision?
Yes, of course. May gives the CMA discretion, and in exercising the discretion, the CMA would have to do it so rationally and avoid irrelevant considerations, which would be the kind of considerations that my lord has mentioned.
So might an innocent party say, well, you know, one thing, making a claim for information, a demand for information against the alleged cartellists, but you only want it because you think I might possess something, I'm a custodian, I'm a bank, what have you. But I'm innocent, and therefore it's an irrational exercise of the power.
A hopeless point, my lord, because the whole point of extending the Section 26 power to people who are not themselves under investigation is because those people often have useful material that the CMA wants for its investigations. The CMA's own guidance, and I have copies of it.
But just to cut your point is that it could be a logical difference in terms of extraterritoriality, being an innocent party and an alleged cartellist. That would go to construction, but the language of the Act is blunt in the sense it doesn't draw a distinction. That's the essence of the point.
Exactly. And the distinction which the court might seek to draw, that we've been discussing, isn't open to you, because that really is the role of Parliament, and we'll see what Parliament did in the bill. But so the CMA's ground one is very, very plain. They say any person means anyone, including people not subject to any investigation, and that can be anyone, anywhere, with no link to the UK. And just to come back to the point about what can that person, the idea that if the CMA issued a notice, it would be possible for the recipient to say, well, we don't think you've got a reasonable basis for the investigation in a judicial review. I think my Lord the Chancellor, and discussed that with my friend, how could an innocent third party, under no shadow of suspicion, ever raise a point like that? All they have is information which may or may not be of use to the CMA. They have no idea about the cartel. They're in no position to engage with the propriety of the notice which the CMA.
We know from European Commission investigations that they issue notices to third parties all the time, and it's absolutely routine in all sorts of cases, abuse cases, cartel cases. It's standard to issue notices to third parties, innocent third parties.
Again, my Lord, I'll come back to that. They issue requests to third parties. Since 1962, since Regulation 17, the Commission has not penalised a foreign party for a failure to comply with an information demand. Under Regulation 1762,
They have the power under 2003. But I mean, just there's the difference. They've got the power, but you say they don't in practice.
That's because, and I'll come to this. The Commission has this power which is being construed as my friend construes it, and we'll see how the Commission itself deals with it. I'll come to that in due course. But it is telling in our submission that they have not done what the CMA now seeks to do, which is to force BMW, for example, to pay a penalty and to enforce a penalty. This Commission doesn't do that. Why not? Against non-EU entities. Why not? Because it knows, just as well as the CMA, about the principle against the extraterritorial application of their powers. And they know that they must respect the sovereignty of other countries and deal with them through mutual legal assistance. I'll come to the practice of the Commission in due course. My own friend skirted over them at a rather high level, and I need to respond to those points. Staying in KBR and the position of a UK company. One sees in paragraph 30 now on page 1265 the difference that the Supreme Court draws between a UK company, which is here, and in those circumstances it can be required to produce whatever it can access abroad. That's not actually extraterritorial effect at all, because it is in the jurisdiction, the legal person is here, and the Supreme Court says that in any event, this casts, the position of a UK company casts no light as to the intention of Parliament as to whether the provision should apply in the very different circumstances of the present case, where the addressee of the notice is a foreign company which has never carried on business here and has no presence here. Now, over the page, paragraph 31, we come to a point that our friend stressed again and again. And the Supreme Court says there's greater force in a further submission on behalf of the SFO. It's clear that an intention to give a statute extraterritorial effect may be implied if the purpose of the legislation could not effectually be achieved without such effect. And the SFO submitted that the territorial scope of section 2.3 must be considered in the light of the public interest in the effective investigation of serious fraud. The very same point is made by the CMA in the context of effective competition law enforcement. And the Supreme Court went on to deal with the legislative history from paragraph 33. But before I move on to that, this point about effective implementation of our competition law, and the point that was made by my friend, that unless section 26 is given extraterritorial effect, it is a dead letter, it has no teeth. The CMA has been enforcing United Kingdom competition law for the last 25 years without, as far as they have explained, ever needing to use section 26 extraterritorially. There's nothing in their papers to show the CMA has applied this power extraterritorially since the Competition Act was enacted.
I thought that point possibly went both ways, because as far as I'm aware, this is the first time the point has been raised coming the other way, that there was no power.
Well, my friend will deal with that in reply, and of course that's perfectly proper to do so, but there's nothing to suggest that CMA is not identifying here, in any of the papers that we've seen, the fact that this is a power which is regularly exercised by reference to specific cases.
Do we? I mean, there isn't any evidence about how often this power is, whether this power has ever been used, as it were, as you would put it, extraterritorially or not.
But if
May or may not have been.
if it were an indispensable tool in the CMA's toolkit, would we see evidence saying, without naming parties, these are confidential investigations, we wouldn't expect to see names, we wouldn't be entitled to them. But there's no suggestion that this is an indispensable tool in their toolkit for the purpose of pursuing cartels, which they've been doing since 1998. So it's impossible in my submission to say, unless it applies extraterritorially, section 26 becomes a dead letter, and the CMA's...
So you rely on the lack of evidence to make that point?
I do. So we come back to KBR and the legislative history, and here, from paragraph 37 onwards, the Supreme Court does place detailed reliance on international mutual assistance treaties. And what we see here, and it's the point that was put to me by my lord earlier on, the Supreme Court relied on the subsequent cooperation mechanisms, the cooperation mechanisms that were developed after the power was enacted in the 1987 Act, to infer that Parliament was unlikely to have intended that the SFO would have a unilateral power to order a foreigner to produce documents here. And my learned friend said, well, it's hopeless to expect the CMA just to ask for documents and information. She said, unless the CMA has a power to compel the foreigner in a foreign country, the CMA is left with nothing, toothless and wholly ineffective. But when one looks at these cooperation mechanisms, which are listed in the KBR case, and again, CMA hasn't said otherwise, there's nothing in them to suggest that any foreign sovereign power or authority can be compelled by the SFO to produce information or documents. My own friend said in submission, well, these international cooperation mechanisms allow the CMA, and the word she used was to require the production of information. But in none of it can it be said that a foreign power can be compelled to produce information from its own nationals for the purposes of a UK investigation. On the contrary, and consistently with the principles of international law, each of them involve requests for assistance. And we see that from paragraph 41 on page 1269. And it goes on, it's my last point, I see the clock. On page 1270, the third line in paragraph 42, the Criminal Justice and Public Order Act involves requests for assistance. Paragraph 43, 3 lines down, the Crime International Cooperation Act 2003, again, 3 lines below that, a reference to requests for assistance. Paragraph 44, United Kingdom and the United States of America has a treaty in relation to mutual legal assistance, in which the authorities can request assistance. The idea that a US authority could be compelled to produce information from a US national is obviously inconceivable. These involve requests for assistance, mutual requests. And at paragraph 45, the Lord goes on to say, I've referred to this history in some detail because it supports KBR's case. Successive acts of Parliament to develop structures in domestic law that permit the United Kingdom to participate in international systems of mutual legal assistance. And but in this, of critical importance to the functioning of this international system, and I rely on this, are the safeguards and protections enacted by the legislation. So it's not enough to say, well, there were lots of treaties and things in KBR, and that's what made all the difference. The reason why that is the right way to get information from foreign countries is because of this, because the provisions are fundamental to the mutual respect and comity on which the system is founded. That is the proper way that one gets information from foreign states, not a peremptory power in a UK authority which will compel the foreigner to produce foreign documents in his own jurisdiction. And for that reason, the Supreme Court said it was inherently improbable that Parliament should have refined this cooperation machinery while intending to leave in place a parallel system for obtaining evidence from abroad which could operate on a unilateral demand of the SFO, same here, without any recourse to the courts or authorities of the state the evidence was located, and without the protection of any of the safeguards put in place under the scheme of mutual legal assistance. So my final point here is that the Supreme Court is referring not only to the fact these agreements exist, but also to the propriety of having them, because by then, the domestic UK power cannot make unilateral demands. The courts and authorities of the foreign country are not emasculated, and the foreigner has the safeguards to which he or she is entitled in his own jurisdiction.
So if you're right as a guide to interpretation, what does the presumption attach to? Is it still the words any person? To guide to interpretation, where does this lead you? Which words are you interpreting using this presumptive guide?
The words any person in section 26. They are limited, as they were in KBR, to any person in the United Kingdom. I've gone rather over my time, I apologise.
Okay. 10:30 tomorrow morning will be.
All rise.